Good morning, everyone. As is our tradition, we will stand for a moment of silence, followed by the Pledge of Allegiance to honor our troops around the world for their families at home and all those men, women, and children adversely affected by war, followed by the Pledge of Allegiance. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you for doing that. At this time, we'll call the St. Louis County Board of Commissioners, and I would ask that the clerk please take the roll.
Commissioner Fink.
Present.
Commissioner O'Neill.
Present.
Commissioner Dahlberg.
Here.
Commissioner Forsman.
Here.
Commissioner Sweeney. Here. Commissioner Nelson.
Here.
And Chair Commissioner Rocker.
Here. Thank you for doing that. In keeping with the theme of this year being the words of wisdom, I will call upon Commissioner Chris Dahlberg, 3rd District, to make his entry.
Well, thank you, Chair Rocker. And I guess as Commissioner O'Neill pointed out last week, this is our last shot at this. And in my theme of self-determination and sort of the founding of this country, I'm going to read this has sometimes been attributed to Lincoln. And actually, I found by my research it hasn't been. It's actually been attributed to a Presbyterian clergyman named Reverend William Boetker, and he wrote this back in 1916. But I think it's easy to see why a lot of people do think that Lincoln was the one that wrote this. And it's kind of known sometimes as Lincoln's 10 principles. You cannot bring prosperity by discouraging thrift. You cannot help small men by tearing down big men. You cannot strengthen the weak by weakening the strong. You cannot lift the wage earner by pulling down the wage payer. You cannot help the poor by destroying the rich. You cannot keep out of trouble by spending more than your income. You cannot further brotherhood of men by inciting class hatred. You cannot establish security on borrowed money. You cannot build character and courage by taking away man's initiative and independence. You cannot help men permanently by doing for them what they could and should do for themselves. Thanks for this opportunity.
Okay, thank you, Commissioner Dahlberg, for those words of wisdom. It's appreciated. As you can see, board members, we have 3 public hearings before us, but I'm going to, because it's in recognition of the time it's going to take to accomplish these 3 hearings, I would move to the opportunity to allow citizens to address the board on items that are not on the agenda, recognizing that for items on the agenda there is time to testify when a motion's on the floor. So if there's anyone here who wishes to bring forward an item, now would be the time to do so. A non-agenda item. Okay, seeing none, we can get right on back on schedule here. I see we don't have any representation here from the county attorney's office at this. Oh, we do. Okay. Our first public hearing, being 9:35 a.m. or thereabouts, pursuant to resolution number 447, adopted September 14th, 2010, to hear the cartway petition of Brian and Tracy Hutchinson of Van Buren Township. And before to start the hearing, I need to read some boilerplate language defining the process and procedure by which we will adhere to. This cartway petition hearing is being conducted pursuant to applicable Minnesota statutes and standing rules of the county board. The standing rules are available upon request. A formal record will be made of this proceeding. Accordingly, we request that all speakers sign in, state your name and address at the beginning of your testimony. Both verbal and documentary evidence will be accepted by the board. The order for the hearing will be as follows. The county attorney will make the initial presentation, being represented by Tim Lee. The public works staff will make a presentation. Thirdly, the petitioners or their representatives may appear and give testimony. Fourth, the affected landowners or their representatives may appear and give testimony. Next, the supporters of the proposed cartway may appear and give testimony. And lastly, opponents of the proposed cartway may appear and give testimony. and commissioners may ask questions of the witnesses at the end of their testimony or at the overall end of testimony, at which time, when that is completed, we'll close the public hearing and render a decision. So at this time, I would call upon Mr. Lee, representing the County Attorney's Office, for his presentation.
Thank you, Mr. Chair.
You might want to move the microphone over there into closer proximity.
The matter before us is a petition for a cartway.
Do we have it on? Okay.
Petition for a cartway under Minnesota Statute 164.08, Subdivision 2, which provides as follows. Upon petition presented to the town board by the owner of a tract of land containing at least 5 acres, who has no access thereto except over a navigable waterway or over lands of others, or whose access thereto is less than 2 rods in width, the town board by resolution shall establish a cartway at least 2 rods wide connecting the petitioner's land with a public road. A town board shall establish a cartway upon petition of an owner of a tract of land that as of January 1st, 1998, was on record as a separate parcel, contained at least 2 acres but less than 5 acres, and has no access thereto except over navigable waterway or over the land of others. The town board may select an alternative route other than that petitioned for, if the alternative is deemed by the town board to be less disruptive and damaging to the affected landowners and in the public's best interest. In an unorganized territory, the Board of County Commissioners of the county in which the tract is located shall act as the town board. The proceedings of the town board shall be in accordance with Section 16407. So that is the statute that brings us here today. This board has established a cartway policy, and under that policy, the Public Works Department provides 2 bits of information for the county board, and we will be presenting testimony with respect to that this morning. Inga Foster from the Public Works Department will discuss her route analysis for the requested cartway, and we will be presenting an appraisal from Mr. John Vegan as to the damages that are incurred by the proposed route. I know this board is aware of several legal issues that have been raised as this matter has come before the board. It appears as I look at the audience that both parties are represented by attorneys who will no doubt give their opinion as to law, and the county, of course, has its opinion as well. At the outset, I will note that we have received from Ms. Kimberly Mackey of the Andreessen and Butterworth Law Firm a letter that indicates an affidavits of service indicating that appropriate postings have been made of the notice of this hearing, as well as personal service upon the affected landowners, Richard and Susan Kochi, and Robin, and Chester Cullen. I will note for the board that the affidavits meet the statutory requirements as to posting and notice. They do not, however, meet the county board's policy with respect to notice, which expanded upon the statute and required 30 days notice. It is the recommendation of our office that the board hold the hearing today. There is a conflict between the board policy, which was established, I believe, by resolution, and the state statute. And in those circumstances where there is a conflict and irreconcilable terms, the state statute would be controlling in the event that the local ordinance or regulation prohibit that which is allowed under the state statute. In this case, the initial determination, in my opinion, is that the state statute does specifically allow 10-day posting and service, and that would be something that would be prohibited under the ordinance or under the cartway policy as drafted. I believe that this is that all the parties are here today to the extent that this is an issue that parties may want to raise on appeal. They certainly can, but I think it would be in the best interest and certainly in accordance with what I believe the law be to proceed with the hearing today.
Okay, that concludes your opening remarks. Do commissioners have any questions of Attorney Lee at this time? Certainly be an opportunity later. Okay. If not, we'll move on then to the presentation by our Public Works staff to give us the historical background on this issue as it affects the Triplet Road, the county's involvement, et cetera. Good morning. If you could please identify yourself for the record and sign in, it'd be appreciated.
Chair, Commissioner Rocker, Commissioners, my name is Inga Foster. I'm an environmental technician with Public Works. I'd like to hand out an alternatives analysis for the cartway. This alternatives analysis examines various environmental regulations that may be applicable to the various cartway alignments. I made a site visit on September 21st of this year along with Steve Johnson, a right-of-way agent for Public Works, to examine the suggested various alternative alignments for the cartway. If you'll refer to Appendix A, Figure 1, and that's also right here in this map. Alignment 1 is basically using the existing road bed of the old North Triplet Road. Alignment 2 is using, in part, the old North Triplet Road bed, and in part, what is a cleared corridor with no road base, and then there's neither a clearing nor a road base along this portion, but it's an extension westward of the existing township road, which is Jarvie Road. And the third alignment alternative is from the termini of Jarvie Road northwest and then straight west to intersect with the old North Triplet Road bed.
Okay, excuse me for a moment.
Sure.
I'm just curious as to whether or not, obviously our audience here cannot see this material, if there wouldn't be some wisdom in using the technology we have here.
I already asked that question.
Is that an option so that the audience could view those screens? Administrator Gray?
Mr. Chair, I don't believe that we have the technology that this is not set up to port into a laptop right now. We can follow up on that, but I don't think we have a flash drive. We just have the hard copies at this point.
I was just thinking, though, with the camera that obviously we have here, if we could zoom on that, and it would pick up on the televisions.
Mr. Chair, the camera is not part and parcel of the screens. The screens are for DVDs and for laptop connections, not the cameras are strictly for the PAC TV.
Okay,
Also, they don't
Thank you.
connect into those.
very good. We made a try. We made an effort anyway. Thank you. I hope everyone who wishes to have a copy of the handout that we are reviewing has one. Is that possible? Is there anyone who does
There's
not
another one. Here's another one over here.
have one? They are available on the front bench there. Okay, apologize for the interruption. Please proceed.
Access option 1 is a segment of Old North Triplet Road beginning at the termini of the publicly maintained portion of North Triplet Road and running south approximately 1,000 feet along the old roadbed to the petitioner's parcel. Although the segment was built by the county years ago, it is no longer considered part of the county's road system. Figure 1 in Appendix A, again, is the map of the different alignments. The former North Triplet Road corridor is centered between Section 24 and Unorganized Township 5221 and Section 19 T52N R20 West Van Buren Township. Within this corridor, the existing road base supports an aggregate driving surface of approximately 16 feet in width. The road base is elevated approximately 1 foot above defined wetlands, and ditches are in place on each side of the driveway surface. There are wetlands present on either side of this corridor. On the west side, there is a type 6 shrub car, which is characterized by alder and willow. And on the east side of the road, there's actually a type 7 hardwood swamp, which has alder, willow, and then also poplar, aspen. As observed on site, recent improvements by the petitioner of gravel to the road surface did not impact the adjacent wetlands, and I'll refer you to Figure 2 in Appendix B. Option 1 is the location of the current driveway used by the petitioners to access their residential property. Access Option 2 would extend from the end of Jarvie Road westerly 3/4 of a mile between the sections of 19 and 30, T52N R20 West, to the intersection of the Old North Triplet Road corridor, and then northerly along the Old North Triplet Road segment, a distance of approximately 1,900 feet, in order to access the subject property. As observed on site, there's a partially cleared corridor west of the publicly maintained Jarvie Road, which ends, you can't see it here because the road alignment actually covers up what's shown on the aerial photo as a clearing through this swamp area, but the cleared corridor ends somewhere about midway on the western alignment. This segment of Option 2 extends approximately 1/4 mile west, but neither roadside ditches nor a road base was observed. Beyond this point, no clear corridor was observed, nor was there evidence of a road base. Once intersecting the Old North Triplet Road, evidence of an old road base is present, and the Figure 5 in Appendix B is actually taken here looking south, so we assume that that same road bed is present if you continued south to where the intersection would be here at the section corner. There are multiple wetland areas present on this alignment, including Type 6 shrub car, Type 7 hardwood swamp, Type 8 open bog, and Type 8 coniferous bog, and those are depicted in Figures 6 through 8 in Appendix B. There is an unnamed tributary to the Floodwood River on this alignment, which is a designated public water subject to the Department of Natural Resources jurisdiction, and a water of the U.S., which is subject to the U.S. Army Corps of Engineers regulatory oversight.
Excuse me, sorry to interrupt, but as we go through and we have these visuals here, the ones in reference to Option 2 are Figure 3 and 4?
In reference to Option 2, that's 3 and 4, and then 6 through 8. And Figure 5 is actually just an example of the existing North Triplet Road base, which is unimproved.
Okay.
Access Option 3 involves the construction of an adequate road surface extending from the end of Jarvie Road northwest to a point approximately 2,000 feet, thence westerly approximately 2,800 feet to the intersection of the Old North Triplet Road base, then north a distance of approximately 240 feet. There is no cleared corridor along this alignment, and there are no roadside ditches or road base until the intersection with the old corridor. This alignment was chosen because, according to the National Wetlands Inventory map, this northwesterly kind of segment of the alignment does not impact documented wetlands. This corridor would, however, impact several hundred feet of probable Type 6 shrub car wetland and would cross an unnamed tributary to the Floodwood River, the same tributary, which is the public water and water of the U.S. Option 1 does not require any additional road construction. Option 2 would require a new road and driveway construction for a distance of 3/4 of a mile. A typical 16-foot wide driving surface would require survey and design work, clearing and grubbing of the corridor, ditching, placement of geotextile fabric, hauling select granular borrow, and a top of Class 5 aggregate for the driving surface. In addition, the crossing of the unnamed tributary of the Floodwood River would require the placement of a large box culvert. Minor work would be needed along the Old North Triplet Road segment, such as culvert replacement, vegetation clearing, and the placement of additional quantities of Class 5 gravel in some areas. Option 3 would require a new road or driveway construction for a distance of 4,800 feet. A typical 16-foot driving surface would require much the same for option 2, survey and design work, clearing and grubbing of the corridor, ditching, placement of geotextile fabric, hauling in select granular and a borrow and a top of aggregate Class 5 for the driving surface. In addition, the crossing of the unnamed tributary of the Floodwood River would require the placement of a large box culvert. Minor work would be needed along the Old North Triplet Road segment, such as culvert replacement, vegetation clearing, and the placement of additional quantities of Class 5 gravel in some areas. Monetary damages would be awarded to the owner of this parcel for the loss of farm income and long-term inconvenience due to any access road angling through the owner's agricultural fields. There are multiple regulatory agencies that would be interested in the construction of either Alignment 2 or Alignment 3. Those agencies are the Department of Natural Resources under their Public Waters Work Permit Program, the Board of Water and Soil Resources as part of their job overseeing the Wetland Conservation Act for the state of Minnesota, and the U.S. Army Corps of Engineers in their oversight for the Section 404 of the Clean Water Act. The Corps' administration of Section 404 includes the consideration of whether or not there are practicable alternatives available to those activities which impact wetlands. A discharge or fill will be prohibited, quote, if there is a practicable alternative to the proposed discharge that would have less adverse impact on the aquatic ecosystem. And under the Wetland Conservation Act administered by Bowser, wetlands must not be drained or filled wholly or partially unless replaced by restoring or creating wetland areas of at least equal public value under an approved replacement plan. The replacement plan cannot be approved by the local government unit, which in this case would be St. Louis County Planning and Zoning, the South St. Louis Soil and Water Conservation District, and a representative from the Board of Water and Soil Resources, unless the applicant demonstrates that the activity impacting the wetland follows the proper sequencing considerations. Specifically, the applicant must demonstrate that wetland impacts have been avoided. To the extent wetland impacts cannot be avoided, the impacts have been minimized, and unavoidably impacted wetlands have not been replaced by restoring or creating unavoidably impacted wetlands have been replaced by restoring or creating wetlands of equal or greater public value. Roughly, that's the avoid, minimize, mitigate principle. Options 2 and 3 would both impact a large area of wetlands if constructed. However, option 2 has the greatest total impact. These alignments may fail the Corps' practicable alternatives balancing test as well as WACA's sequencing considerations, as option 1 has minimal to no impact to wetlands.
Does that conclude your presentation? Commissioners have any questions of the Public Works representative? Commissioner Fink.
Thank you, Mr. Chair. Under options 2 and 3, you mentioned that there would be a great deal of additional work that would be necessary to bring those to standard. At whose cost?
I believe that would be at the petitioner's cost. Is that correct?
Okay. And under your conclusions, where you speak about options 2 and 3 both having a substantial impact on wetlands, where does the property owner's rights play in this particular game, particularly the two who might be impacted by having a cartway across their property? Demonstrate to me through your knowledge of the Wetlands Acts and whichever, who gets the greater consideration, the government and its wetlands or the private citizen?
The government and its wetlands typically, because the wetlands are often waters of the U.S. as well as subject to the Wetland Conservation Act. Though Section 404 of the Clean Water Act, it roughly refers to jurisdictional wetlands, or those wetlands that have some kind of connection to a larger wetland complex. Section 404 does not contemplate what are termed isolated wetlands. Those aren't under the Corps' jurisdiction. However, the Wetland Conservation Act, as administered by Bowser for the state, does have jurisdiction over isolated wetlands. And so broadly, you know, if you're making just kind of a you know, general assumption that all wetlands are subject to both Section 404 of the Clean Water Act under the Corps' oversight and the Wetland Conservation Act under the Board of Water and Soil Resources oversight. There are exemptions for each of those regulatory programs, but they're for a very minimal area. For example, the Corps of Engineers de minimis area is 400 square feet, and the Wetland Conservation Act, it depends how far you are from a public water, and if that, what kind of wetland it is, and anyway, it's roughly 10,000 square feet, but it can go down to as little, I think, as 200 square feet, and it depends on the kind of wetland it is and where it's located.
Let me make sure that we are both talking to the same question. Most of what you said, I have some basic knowledge of. The question is, whose rights are the most significant? The wetland rules, as government would present it, or the private rights of the property owner?
I can only speak on this, you know, looking at it from the public works perspective, but the burden is on us as when we're an applicant for public works to show that we have undergone the correct sequencing and that we are avoiding, minimizing, and mitigating. And when there is a practical alternative that avoids, minimizes, or in some cases mitigates on-site impacts for wetland, that is always the preferred alternative from the regulatory agency's perspective.
Thank you.
Other commissioners have questions? So that I can better understand these alignments, with respect to the map you have, could you show me, with respect to alignment number 2, what portion of that road actually exists and what would have to be developed?
Okay. The existing roadway that has a roadbed and an actual base actually ends at the property just west of the Jarvie Road, several hundred feet of the Jarvie Road. From this portion all the way west to the intersection with the North Triple Road, there's actually no in-place roadbed. There is a clearing to approximately this point, but there's no road base, there's no ditches. When you walk on this cleared area, it's actually it's spongy. It kind of has a jello-like feel when you walk on it.
Much the way the entire area was prior to any human occupation?
Yes.
Okay, and then does that also account for, I understand there was a decision recently by the local town board to accept some portion of extending that driveway, was there not? Some decision by the town board to
I believe that
extend a portion of that road further? Or is that the 700 feet you mentioned?
that was the west side of the driveway, is that right? Okay.
Answer's no. Okay, and then with respect to alignment number 3, is there any portion of that, since you don't have any visuals to look at, that is currently a developed road?
No.
Because I'm somewhat curious as to how the Hutchinsons, John Hutchinsons, access their property.
There may be a trail in place and kind of an informal trail, but there is no roadway in place along that alignment.
So you're telling me that from the Jarvie Road to the home of the Mr. and Mrs. John Hutchinson, there is no access? They don't have access to their property? How do they access their property?
They currently use alignment 1.
No, I believe that's the question that's what the cartway is about, is to grant access over that current alignment. But do the other Hutchinsons who live there, the parents, do they have access off the Jarvie Road to their property? Attorney Lee.
Mr. Chair, I suspect there probably can be some testimony from others in the audience with respect to that, but it's my understanding, and again, I think you would want this from testimony to establish whatever facts you feel are important, but I believe that is vacant land. It is not the homestead of the John Hutchinsons.
Okay, they don't, okay, I was under the assumption that they lived there.
I do not believe that's the case, but again, I'm sure there are others who can address that fact with certainty.
Okay, if those who are in the audience who plan to testify, if there's some accommodation could be made of that question, it'd be appreciated. Thank you. Any other questions for Ms. Mattson? Commissioner Forsman?
Just to underscore, option 1 is the only one that does not have a wetlands impact on it?
Correct.
Okay, thank you.
Okay, seeing no further questions, thank you very much, and you'll be available for questions if needed afterwards. Thank you. Okay, that brings us to the third bullet, which is petitioners or their representative may appear and give testimony.
Mr. Chair, we have
Excuse me.
just a few other items that
On
we
Public
would-
Works, okay.
that we would present on behalf of Public Works. And the next matter we would like to address is the appraisal that was done by Mr. John Vegan of Ramsland and Vegan, which analyzes the damages associated with the route, with proposed Route 1. And we would ask Mr. Vegan if he would come forward in anticipation of that.
Good morning. If you could identify yourself for the record, it'd be appreciated, and sign in.
My name is John Vegan, V-I-G-E-N. I'm a partner in the firm of Ramsland and Vegan. We are a real estate appraisal and consulting company located in Duluth, Minnesota.
And before Mr. Vegan begins his explanation with respect to his appraisal, I would note to the board that copies of this appraisal were provided to the attorneys for both the Cullens and Hutchinsons when we received the appraisal. Okay, Mr. Vegan, I guess I would ask that you describe for us how you became involved in this process, how you went about making your appraisal, and what conclusions you came to as a result of that appraisal process.
All right. President Rocker, Commissioners, I was retained by the St. Louis County Attorney's Office to value a proposed cartway right-of-way. And a cartway right-of-way typically is 33 feet in width. Due to some circumstances, my instructions were to appraise the westerly one-half of the proposed right-of-way, which comes to 16.5 feet in width by 1,320 feet in length, which equates to 1/2 acre. And I think that is spelled out in my report. To accommodate that, I sent out a letter to the property owner and under the public notification law, and I did not receive a response to that letter, and so I went out one day to look at the land and found the property to be a what I would refer to, and technically perhaps it's not correct, but I would refer to it as kind of the remnants of an old logging road of some type. There appeared to be a corduroy, an old log bed that was in there, gravel having been put over the top of it, and it extended from the northerly quarter section line southward about 1/4 and ended. At the time that I was there, the property owner had placed some posts or pins down what I presume to represent the edge of the actual property line down this alignment. And I did notice some survey pins in there, and I presume that they were done by the county highway department, trying to set the alignment for this. And those show in the photographs that are in the rear of the report, and And you can see that there's a road bed, although it's rather rustic, we would refer to it as a truck trail, I would guess, that would provide access from the county road, which is improved, to Mr. Halverson, is it, or Hutchinson's property. And when I do an appraisal, or when an appraisal is done on a cartway easement, it's much the same as you do when your evaluation process that you use with a pipeline or a power line or some other type of utility or roadway corridor. It's typically an over-the-fence type of analysis. You look at the value, you try to estimate the value of the land that the easement is crossing, and if there's going to be any other damages to the property where the road will be, such as timber removal or other types of issues that may constitute a value. In looking at the property, because of the existing road bed, there was no timber or merchantable timber in place that would be removed. I would imagine that the road bed would be reconstructed somewhat. Ditch banks would be improved. There were ditch banks on both sides, but I would expect they would be improved. So I looked at land sales within the general district out there, and on page 8 of the report, there are 5 of these sales listed, and they are current sales. 4 of the sales occurred between February of 2010 and June of 2010, and the 5th sale occurred in July of 2009. And the sales were all of 40-acre parcels. One was a 38-acre. And they ranged in price from from $775 per acre. Per acre is the unit of comparison that we would use in this matter. So $775 per acre to $1,750 an acre, and that's a broad range. But generally, you would suggest that because of the character of the land, and the land is it's certainly usable land. The land neighboring it is usable land. Portions to the west would be in pasture land. There are some wetlands that abut, as you heard from earlier testimony, and there are some woodlands that abut. It's the kind of land that would be used for maybe light agriculture, hunting, recreation, that type of thing. And my value estimate was stabilized towards the upper end of that value range, or $1,400 per acre. And we're only dealing with a half an acre of land here, and so that unit of comparison applied to the half an acre results in a compensation of $700. In my estimation, the creation of this cartway and to use it as an access road for residential driveway would not impair the use opportunities of Mr. Cullen's property from which it was being taken. Mr. Cullen's developed properties are some distance away, and so there's not a visual impact, there's not a sound impact, and there's a combination of open pasture land, forest, and so forth that separate the cartway, the proposed cartway, from the homesteads, and so there were no other consequential damages that I would put on this particular property. And that, in essence, is my process for estimating the cartway value.
Okay, do commissioners have any questions of Mr. Vegan? At this time, Commissioner Fink.
You mentioned early that your thought process was that this appeared to be a corduroy road.
What I mean by that is that as I looked, and I did walk down the ditch banks, and I did walk along the road, and there seemed to be evidence in some locations where somebody had laid logs down, you know, and that's a pretty common practice on some of those old logging roads. They would lay some logs down, throw some gravel or something over the top just to make a driving surface. They're certainly not a built road bed as we expect road beds to be built, that's serviceable in those kinds of locations. Now, that seemed to be my observation.
2 questions along those lines. What are typically corduroy roads used for?
They could be used for a number of different things. I have seen them where logging companies, you know, if there's land south of here, the county plot book page, let's see if I can find it in this report here, is in the addenda of my report, and you'll notice that lands to the south of this are owned by Blandon Paper Company. There's some state of Minnesota tax forfeit lands. Although I do not, and I did not research this, a neighbor, Mr. Kochi, if I pronounce that correctly.
Cucci, I believe.
Kochi, I met on the road, and he had advised me that over the years, people had used that road to get south to log, you know, off of it. You also find a road like that where perhaps deer hunters are getting into a camp, and they really don't want to build a, you know, traditional type of road in, but they're just doing things to keep the sink factor.
The sink factor,
Well, what I mean, if you're going across soft land,
okay.
you can supplement your ability to get a truck in over it, you know, just by laying those kind of things down. In some instances, it was available with lockers.
And you mentioned also that there might need to be some improvements along the road?
By the nature of the road, Commissioner King, and again, the photographs show it, and I hope you have those in your report, show it fairly clearly that it's a meandered kind of a bed that's in there, and it's, you know, a little bit up and down, a little dipsy-doodle. And I would expect that if someone was to get a cartway on this, that they would smooth that out and they would make it a little bit more appropriate for driving on a daily basis. But those are my own opinions.
I'm trying to stay away from the opinion too, John. I'm looking at this and going, okay, what if somebody goes in there and works on that? It's probably not a question for your appraisal. Thank you.
Okay, do other commissioners have other questions of Mr. Vegan at this time? I guess I would just want to ask for clarification, and just in looking at the document you provided us with, under the portion of intended user and use of appraisal on page 3, just if you could add a little clarification to the statement there that speaks to the intended use of the appraisal.
Generally, in a real estate appraisals, we're required on our professional standards to say who we're writing it for and why are we writing it, so that it isn't used inappropriately for other purposes. And I've identified in here that the intended users of this appraisal are the parties essentially involved, the St. Louis County, Mr. Cullen and Mr. Hutchinson, property owners, their attorneys, if they were going to be using that, and others who may be party. And the intended use of the appraisal is for negotiations and settlement on a cartway right-of-way dispute. In other words, if my value estimate is $700, that may become the basis for negotiating a settlement, you know, in this assignment for the purpose of this. And that's why we put those in there.
Okay, thank you for that clarification. And then I have to ask, with respect to your comparables, did any of those comparable values have, were those simply raw land?
Those are raw land.
Okay, so was there value given to the consideration given in determining the value of the said cartway to the fact that it has the investment of road improvements?
Well, as I perhaps did not state very clearly, but I would think that if someone was going to use this road, the degree that it's improved at this point
Has value, correct?
It has a value, but it's not the type of roadbed that you probably would leave in place if someone was going to use a permanent driveway to their home or to some other purpose. You would come in and deconstruct portions of that and reconstruct. In order to get the proper culverting in there, you would want to put in culverts so that the wetlands would drain, you know, either side of it. You'd want to put in a more stable base. You'd want to put in a more stable surface and so forth. So the fact that that's been laying there, the ballast is not, in my estimation, is not a permanent type of a ballast that would be in place as we might configure on most roadbeds. It appears to be a kind of a, I won't say temporary, but what you'd see in a forest logging road.
But in comparison to raw land,
The raw land comparables that I'm looking at, and remember that I'm valuing the cartway ordinance as part of the 40. And so the lands that have sold are all had road access, all had road frontage. And so this is valued the same as having that. I did not parcel out a contributory value for any of those logs or roadbed or anything that might be in there. But the value was stabilized at the upper end of the value range. It did run from $775 to $1,750, and I did stabilize it at $1,400 an acre. And within that, if one wants to consider some unknown number towards the existing fact that you can drive on part of it, that would be acceptable.
Okay, thank you very much. Commissioner Forsman.
Thank you, Mr. Chair, and just my comment on the corduroy roads there and stuff is that part of our family is still driving over corduroy roads that my grandfather put in there, and they're not sinking down in the swamp yet there, but that was many years ago. So, I mean, granted, they do have a lifetime, but sometimes that lifetime's longer than people think it will be there, so.
The one observation I would have on this road is that I would think whatever is going to ultimately happen with this road right-of-way, that if somebody is going to use it as a permanent road, that they would be dealing with drainage issues from one side of the road to the other side of the road, which would mean that you would have to excavate part, put some culverts in and do that type of thing.
That was my question.
Okay, are there other questions by commissioners at this time? Attorney Lee.
Mr. Vegan, I just wanted to call your attention to page 8 of your appraisal, and I know your testimony today has been with respect to units of value on a per acre basis, but I see right at the bottom of page 8 a reference to per square foot.
Well, that's a typo.
I just
I'm
wanted-
glad you caught that.
I just wanted to clarify that, you're of the opinion that the per acre evaluation is the appropriate measure of
That's great.
evaluation.
Okay. If there are no further questions, thank you for their testimony, and you'll be available in the event additional questions arise. Thank you.
Mr. Chair, the last bit of testimony we would present from the Public Works Department would be Public Works Director James Oldesy, who will testify as to the costs that have been incurred by the county in the appraisal process and in the preparation of the road analysis.
Thank you, Chair, Commissioner Rocker, and Commissioners. As Attorney Lee said, we have to, well, two things. One is the petitioner deposits $4,000 actually with the county to cover the costs of the Public Works Department in basically reviewing the routes or analyzing those routes, and then also facilitating the appraisal of the property. And so what I've handed out to you there is basically our costs, our internal costs, which are costs for Steve Johnson, right-of-way agent, and Inga Foster, environmental technician, and then also the Ramsland and Vegan appraisal costs. Totaling those two items together, we come to an amount of $3,298.88, which would be taken from that $4,000 deposit.
Do commissioners have questions of Mr. Follacy at this time? Commissioner Fink.
Mr. Chair, will we get an opportunity to get Ms. Foster to comment on, or should I be asking Jim questions about the wetland impacts or lack thereof on this existing road? What I'm interested in is that Ms. Foster pointed out that there would be no wetlands impacts on the existing road. Mr. Vegan testified that this was a corduroy road and that may need some repair, and in order to do that, there was soft ground on either side, which would indicate that there would be a wetland impact. And so I'm wondering if we've missed something here, or if we have to clarify this now, or if we wait till later on to clarify it, because it seems to me that, first off, most of us know that have been played in the wetlands area, that corduroy roads were intended to harden up the ground so that people could in fact traverse across it. And I'm concerned here that we don't miss a very valuable point about the wetlands impact if any repairs are done on this road, or does this road eventually, and Commissioner Forsman said it really well, that the corduroy roads last for a long, long time, but they don't last forever.
Chair, Commissioner Rocker, Commissioner Fink, I can answer that question. It all depends on if this cartway petition is successful, let's just say in the eyes of the Hutchinsons, and the option 1 alignment is granted, it depends on what that individual wants to do with that road. Essentially what is happening is you're establishing the cartway, a right-of-way
that this person can now access their property. What they do to improve that is up to them. So if we're looking at just the existing condition right now, and if it's going to be left in that condition, it's deemed suitable by that person, the wetland impacts are 0. If they determine that they want to improve it within the limits of the right-of-way of the new cartway, then they would have to go through a process of going through the permitting, determining what the impacts would be.
You know, I'm not so sure that's right. Your staffer said that the rights of the government supersede the rights of the individual landowner. If you grant a cartway where there's public testimony that the grounds are soft and wet and there's a corduroy road in there, why won't government come back and say, before you can utilize this road, you must adjust it to the current impacts or the current wetland impacts that have already existed? We have within, at least in this county, our planning group and several other organizations within here who is supposed to do this have gone into certain properties and asked them to remove corduroy roads. Shouldn't we not take into consideration the fact that there is a wetland impact here?
No, what's in place is in place out there. If you're going to do any planned improvements, that's when you get into the permitting process.
Thank you.
Other questions or comments? Commissioner Nelson?
Thank you, Chair Commissioner Rocker. I guess my comment is really to Director Faldesi as well as to administration. One of the things that when we put these costs into place and we ask that these dollars be fronted, one of the things I don't see on here is administrative costs. And I don't see several other costs, and I guess I'm okay with the Hutchinsons getting a deal on this one, but in the future, I want to make sure that we bring forward fully burdened costs for St. Louis County taxpayers, because I know this 3298 reflects the vast majority of the costs, but I'm also certain that there are other costs that we have incurred that are not reflected in this statement. Thank you, Mr. Chair.
Sir, Commissioner Rocker, Commissioner Nelson, I guess as far as the wages that are reflected on the sheet in front of you, those are burdened. You'll see a little bit further down the burden rate of 1.62%. So we've burdened those. If you're talking about other costs, let's say from the assessor's office or the auditor's office, those other costs that are incurred, that we can look into.
Mr. Chair, that is what I was
Good point.
pointing towards, that there are other costs that we are incurring, I believe, and knowing that this is really one of the first cartways that have come before us since we put that cost factor into place. I want to make certain that at the conclusion of this, that we review that and make sure that for future cartway petitions that we fully burden those costs. Thank you, Mr. Chair.
Point. Commissioner O'Neill.
Thank you, thank you, Chair Rocker. Commissioner Nelson makes a good point, and I wonder, Jim, if reflective in those costs are today's costs. I mean, I assume you and your staff are going to be here for at least an hour, maybe a couple hours, and I assume that those costs will not be reflected in what you've given us.
Chair, Commissioner Rocker, Commissioner O'Neill, that's correct. I guess we try to make a judgment call on what we think is fair and reasonable to charge back to the applicant.
You can't, yeah, I'm not asking that we undo what you've done today, but it might be a good thing to consider for the next one. Thank you.
Only so many ways you can split the hair. Correct. Commissioner Dolver.
Thank you, Chair Rocker. I don't mean to beat this to death, but it does raise a little interest with me, and so I'm going to keep on the burden rate. My question just, Jim, is this, and my hope is that this number isn't a 1.62 across the board, or how does that burden rate factor in there? You've got this ratio of basically a 0.62. So can you tell me how that?
Sure, Commissioner Dahlberg, basically the 1.62 burden rate is a number that comes from the auditor's office that is applied to labor in public works. That is reflective of overhead, actual overhead of sick leave, vacation, healthcare costs, all of those things. So the rate, you see there for Steve Johnson, the hourly wage rate, that is multiplied by 1.62 to arrive at the fully burdened rate. So it's an audited burdened rate.
Well, it's interesting because it's some extra overhead costs, but we were talking earlier about administration costs being factored in here. So that would be factored in from the auditor's office?
When you say, no, those would be, what you'd see here is additional hours from, let's say, a personnel in the auditor's office.
Yes.
That's what Commissioner Nelson was asking for.
And that's in here?
That is not. You just see the public works staff.
Okay.
Here right now.
Okay, and that's my concern too, is that something like this, you have these fixed costs in here, and the ratio really is gonna be much more expensive on a smaller project than a larger project as far as hourly. That would tend to go, so that is, if you have a certain amount of labor costs that are involved, perhaps your management would be there's a certain fixed cost of overseeing that.
That's correct, and if you were to, if we were to account for every hour that we've been involved in this, yes, you'd see Jim Faldesy on here with the rate. It would be again burdened by that 1.62 audited burden factor. If we were to totally justify every nickel that we've spent on this.
Commissioner Nelson.
Mr. Chair, and I apologize to you and to this board. It was not my intent to change what should be what this board is reviewing today, which is the cartway petition. My sidebar was in hope and anticipation that upon conclusion of this cartway petition, which is really, again, one of the very first that we've had under those new rules, that we would reassess, at least internally, to make certain that we are fully burdening and collecting all of the costs incurred. But it was not my intent to change the tone or tenor of this meeting, because it is about the cartway, not necessarily about our costs at this point. Thank you, Mr. Chair.
Director Faldesy.
Sure, Commissioner Rocker, Commissioner Nelson, I've heard what's said here. I've heard the questions. We have another cartway coming up here in a few weeks, and we'll be adjusting these things. It's been a long time since I think one of these has been taken before the board, and 4 years. We're going back through the learning curve.
Okay, any other questions by commissioners? I have but one, and in trying to, looking back on the presentation on the alternatives, as well as in relationship to the comments of the appraisal, Mr. Vegan, is it fair to, in trying to assess these on an apples-to-apples basis, is it fair that in determining the merits of the various alternatives 1, 2, and 3, that zero consideration would be given, obviously, in the comparables to the value of the road? Therefore, in determining the merits of alternatives 2 and 3, little or no consideration should be given to the value or investment that would be required to make those alternative routes viable roads.
I think that the more important issue is the environmental impacts in the
Those could be
evaluation.
mitigated. Those are cost items that would be mitigated. So, and it's an overall cost associated with the development of a roadway.
In theory, with these alternatives, you could run into a situation with one of these agencies that we have to deal with, or the petitioner would have to deal with, that would refuse it, based on avoid, minimize, and mitigate. You have an alternative that minimizes the wetland impacts, and you could run into a situation where they will not grant you the permit.
Right. Quite possibly, yes, I understand that, but my question is more directed at, in view that the no value was attributed to the option alternative 1 for its road value that exists there. It was compared to raw land. Thus, the other alternatives should be assessed and determined as raw land. There may be regulatory issues that could circumvent those from getting proper permits, but we should not be giving consideration to the dollar value that would have to be would be required to to convert those alternatives to actual roadways. I'm just trying to ascertain that in my mind as an apples to apples, so maybe there isn't an answer to that.
Yeah, I think that's really the decision of how the board wants to view this petition.
Very good. Attorney Lee, did you have a comment on that?
I thought this might come up at a later time, but essentially what the Supreme Court has indicated is that a town board, or in this case the county board, in establishing a cartway is to provide a meaningful access to the petitioner's land. And in cases that have looked at alternative routes, the cost of construction of alternative routes could be a factor that the board